Welcome to Prince Short and House. Exercise number 72, legal real judgments, 100 words a minute. Ready? Start. It is also submitted that no other material witness of fact remains to be examined. On the other hand, the APP for the state has submitted that this court has not to scrutinize the testimony of the witnesses at this stage once the complainant has fully supported his complaint made to the police, which fully support the prosecution version. The doubt expressed by the applicant about the presence of Farooq (PW1) at the spot is a matter to be appreciated by the trial court taking into consideration all the facts of this case. At this stage, when direct allegations have been made against the applicant by PW1 coupled with other circumstances which goes to show that the petitioner is the person who caused the fatal blow with the iron handle on the head of the deceased which caused his death, coupled with recovery of weapon at his instance, points out his involvement in this case. Moreover, the report of the doctor who conducted the post-mortem, which also opines that the injury to the victim is possible with the weapon recovered in this case, is another circumstance which cannot be ignored. Merely because the petitioner was released on interim bail on account of the illness of his wife does not entitle the petitioner for regular bail, taking into consideration the gravity of offense and the conduct the accused as deposed by PW1. The role of the co-accused persons who have been released on bail is that they caught hold of the victim, and therefore there is no parity between the case of the petitioner and the other accused persons. Even otherwise, the points mentioned above about the reliability of the statement of PW1 are matters which may be explained by the investigating officer when he appears in the witness box. The submissions that the complainant has not indulged himself in the fight and has not come forward to save his brother, and for that reason he has not even suffered any injury, cannot per se disprove the presence of the witness at the spot, because reaction of a person faced with similar circumstances would depend on his personality. The complainant has taken the deceased to the hospital where the deceased succumbed to his injuries. This is what he stated in his complaint made to the police. Merely because the other witnesses have not supported the prosecution and have caused some dent in the case of the prosecution, it cannot prima facie be believed that the petitioner is innocent. In any case, the evidence which has come on record cannot be scrutinized by this court at the stage of granting bail, as has been stated by Supreme Court in Satish Jaggi versus State of Chhattisgarh. Learned Counsel for the state also relies upon a judgment in Ved Prakash versus state, wherein it has been held that the nature and gravity of the charge and the severity of punishment in the event of conviction are required to be taken not of while considering the grant of bail. I have also considered the judgments cited at bar by the petitioner, but I do not find are of any help to the case of the petitioner for his release on bail pending trial in the facts and circumstances of this case, looking to the gravity of the offense for which the applicant has been charged, because neither it is a case of Prevention of Corruption Act nor the petitioner has completed 5 years in judicial custody. Even otherwise, there is no parity of his case with other co-accused persons. The bail application is accordingly dismissed. Stop.